In this video, I want to share with you an example of how new technologies can stress old copyright laws. And to do that, I want you to think about professional basketball a few years ago, specifically in 2016. At that time, Kevin Durant was leaving the Oklahoma City Thunder, and a lot of teams were interested in signing him. One of them obviously was the Golden State Warriors, where he ended up. But other teams were also trying to attract him to play for them. One of those teams was the Boston Celtics. And there was a rumor at the time that Danny Ainge, who was the general manager for the Celtics, was going to put on a full court press to convince Durant to play for the Celtics. In fact, the rumor went so far to say that Ainge was going to enlist Tom Brady to chat with Durant and let him know how great it is to play professional sports in Boston. So, while this rumor is going on, an individual named Justin Goldman is visiting the Hamptons, which is an exclusive resort in Long Island. And while there, what does he see? Danny Ainge, along with Tom Brady and Kevin Durant, together having a conversation. So naturally he says, I've got to take a picture of this. And then, of course, he has to share it on his social media. And so he puts it up on his Snapchat account, which typically is only available for 24 hours. But then other people, one being Bobby Manning, see the picture on Snapchat and think, oh, I have to share that from my social media platform. I don't know exactly what specific steps Bobby Manning took, but think of what you often do, such as take a screenshot of a photograph, which then goes into your camera roll. And then you post that copy of the photo on, let's say, your Instagram page. Manning did something like this and posted the photo on his Twitter account, where anyone could see it. Then, some news organizations like Breitbart, the Boston Globe, and the Herald became aware of Manning's tweet, and they decided to include the photo with stories speculating on efforts to get Durant to come to Boston. The newspapers incorporated the photo through a process called embedding, and Goldman sued them in a New York district court for publicly displaying his photo without permission. Let me just take you through the PowerPoint slide for a moment. Start on the left, where Goldman uploaded the photo onto his Snapchat story. And obviously, he authorized the public display that he made of his photo. But then Bobby Manning, among others, made a reproduction of that photo by a screenshot or whatever, without permission from Goldman. So the copy Goldman made was an unauthorized reproduction. Then, when Manning included the photo with his tweet on Twitter, he made a public display, which Goldman also did not authorize. None of these actions by Manning were the subject of the lawsuit, although Manning likely infringed Goldman's copyright. So I don't want to focus on the left side of this slide so much. Rather, I want to zero in on the right side, which depicts how Breitbart and the news organizations embedded the image from Manning's tweet into their stories, which Goldman claims violates his exclusive right to display his copyrighted photo publicly. Breitbart asked the judge to dismiss the case right out of the box, saying essentially, look, Judge, can't you see that we're not even displaying Goldman's photo by embedding the image? Rather, Manning is making the display, and we're just basically letting our customers view what Manning is showing. So Breitbart claims that it has not violated any of Goldman's rights at all. It didn't reproduce the image, nor display it. Only Manning did these things. Thus, it is asking the judge to dismiss the case against it immediately at this preliminary stage of the proceedings by a procedure called summary judgment. If the judge buys that argument, then the case is over and Breitbart wins. However, if the judge believes that Breitbart has made a display, then the case will go on, because Breitbart might still win based on other arguments, such as perhaps that it is a fair use for a news organization to display the work to help inform the public about current events. However, Breitbart would prefer to put this to bed now, without relying on defenses such as fair use, as would so many others who could potentially be sued for embedding photos when fair use may be even less tenable an argument. So the key to this case comes down to who is actually making the display when Breitbart embeds the photograph from Manning's tweet. Is it Breitbart or Manning? And to answer this question, we have to delve a little bit into some general notions about web design, which I indicate here as dynamic, because one can easily make changes on the fly, unlike with a printed book, which is static. So, take my textbook, which I wrote in 2010. Several important things have changed since then, such as with patents and novelty, which have made certain sections of the book obsolete. Wouldn't it be nice if I could easily remove the old sections and replace them with updated information about patent reform? The same with the discussion about patents for computer programs, which I would love to revise in light of the newer Supreme Court cases. But I can't, because a textbook is static, and so the only way to revise portions of the book is to rework the entire thing. Websites, on the other hand, can be designed to be dynamic, so that aspects can be easily cut and pasted or rearranged. For instance, suppose I want to build a website that provides information about selected important individuals. I can place various elements that might be relevant, such as text, photos, or videos, in my own storage area, which we'll call a server here, and then instruct the computer to grab, arrange, and size the items I want to be included with what is called HTML code. You can think of this code as saying, go to this particular address location on this server, get what's there, and put it on the computer display in this spot in this way. If I want to move an item, I can just change the HTML code to make it appear in another spot. If I want to include another item, I can just change the address location for something new. For instance, if I want to show the beer bottle instead of a text document, I can easily do that with a new source address. What is perhaps more powerful is that when items are stored on a server with a unique address, then others who know that address also may be able to grab it. So, for instance, when I store an item on my server, other individuals who know the server address of that item may gain access to it. Similarly, I may be able to find and access relevant items on servers run by other institutions and organizations that are basically doing the same thing. For example, Cal Poly has a server that stores lots of photos and documents with unique addresses. I might say, man, it would be nice to have a picture of President Jeff Armstrong on my site. And lo and behold, Cal Poly's server has lots of them. And so, as long as I can determine the address of the one I want, I can instruct the computer to access it so that it appears as I wish on the screen. Similarly, I could go find a picture of Brett Kavanaugh on a government computer and add his photo to my site. And if I later decide that I no longer want to show Kavanaugh, I can easily remove him and, well, You see, the sky's the limit. It's great because it's so dynamic and flexible. Now, a couple of other items worth noting here. First, although we think of going to a website to find information and see things, what is happening under the hood, so to speak, is that when we visit a website, the site sends the HTML code to our computer, and then our computer requests that the various pictures and documents appear on our screens according to its instructions. The other issue regards who ultimately controls what can be seen on the screen. For instance, if Cal Poly decides to remove the picture of Jeff Armstrong from its server so that it is no longer at the original address, then websites that previously accessed that photo of Armstrong via HTML code will now show a blank space where President Armstrong once appeared. Or if Cal Poly files a different photo at that address, then this new picture will appear on the websites that access it. So, although it may seem intrusive that others can call up photos stored in this way on Cal Poly's servers, Cal Poly ultimately has the power to prevent further access. What makes the issue of embedding so interesting and confusing is that there are two different ways to conceptualize how web designing allows website visitors to see the information on their computer screens. One way to consider what is going on is depicted on this slide, and the course referred to it as the Incorporation Test. With this lens, what I'm doing as a web designer is going out into cyberspace and selecting the elements that I then incorporate into my web page so that people who visit my site can see them there. In fact, this is probably what most people think is going on. The website shows me stuff, or in other words, displays it when I go there. However, this is not the only way to conceptualize what is happening. If you peer a little deeper into the functionality of the web, then the servers storing the materials make those items available for others to see as long as they know the address of where to look. The HTML code does this work by instructing the computer where to look and then how to focus the items onto the screen. It's like instructing a person to point a telescope on a specific distant star and focusing the image to a particular place on a background screen. Courts refer to this conceptualization as the server test. In a sense, you can think of the web designer here as a conductor that orchestrates how you see what is already being displayed out in the universe. And if this is the model, then the website does not directly make the displays, but rather the individual servers do. You can see how the choice of model might affect the outcome of disputes regarding embedding content. For instance, if you follow the incorporation test, then Breitbart is displaying Goldman's image when visitors come to its web page. However, if you use the server test, then Breitbart is simply letting visitors see what Manning is displaying from his Twitter account. So how do the courts approach all of this? Up until somewhat recently, the leading decision was by the Ninth Circuit Court of Appeals in a lawsuit by Perfect 10 against Google. The Ninth Circuit, by the way, covers the state of California, and so is an important source of opinions about technology issues. Here's the background of the Perfect 10 case. Perfect 10 is an adult entertainment site that is only available to those who have a subscription to enter. One of its subscribers made unauthorized reproductions of some photographs from Perfect 10, stored them on his server, and then made those photos available on his website. His was not a subscription site, but rather available to the public so that anyone could access it and see what was on it. This, of course, means that Google could also find these photographs. And when it does, it includes them on its image search engine, which, as you know, means that it makes thumbnails of them, and then if you click on the thumbnail, you could see the full-sized image. With the thumbnails, Google actually has to make a reproduction of the full-sized image, reduces their size and resolution, and then displays the small versions from its servers. Perfect 10 sued for these reproductions and thumbnail displays, but loses on the same theory as with the Ariba case that we covered in class. The thumbnails are a fair use because they are used in a transformative manner and don't hurt the market value for the original images. Perfect 10 also sues for the display of the full-sized images within Google's website, claiming that Google is making an unauthorized display. Unlike the thumbnails, Google might have a harder time demonstrating fair use, so it argues that it's not making the display. Rather, it is simply embedding an image that is being displayed by Perfect 10's errant customer. Thus, the Ninth Circuit had to choose which model to follow, and it picked the server test, meaning that Google does not make the display, but only points to it. In substantiating its choice, the court referred to another section of the Copyright Act and concluded that one must possess a copy of a work to display it. Since Google did not have a copy of Perfect 10's full-size photo in its servers, it could not display it. Well, I can tell you right off the bat that this requirement about possessing the copy to display it is probably incorrect. For instance, if you run a bar, such as Milestone, and turn on the TV for a sporting event, then this is considered a public display under the Copyright Act, even though Milestone doesn't have a copy of the content in its computer servers. Instead, the content probably comes from ESPN or Fox, and Milestone is just showing it to people who come to the bar. So, I will just say here in passing that the Ninth Circuit's conclusion is not mandated by the Copyright Act, and so is questionable. Nonetheless, it picks the server test as the appropriate model to address embedding. Thus, Google wins its argument that it's not making the display of the full-sized Perfect 10 images. The last bullet here is a concept we're going to discuss at another time in this course. Here's the arrow for it. But just because Google does not directly display the work does not mean that it is necessarily off the hook. This is because it is helping people find content that might be posted unlawfully. And there may be circumstances where it might be appropriate to hold it responsible for furthering the unlawful conduct, even though the illegal actions are performed by someone else. We call this notion contributory infringement. For instance, what if Google knew that the images were unlawful and yet continued to help its customers find those photographs? Anyway, this is not the specific subject for today, but it's worth thinking about at another time. Okay, let's circle back to embedding and the Ninth Circuit's adoption of the server test. And just to reinforce the concept, here's the full-sized picture of Jeff Armstrong at the address on Cal Poly's server. That's what you will see if you put that address in the browser bar. And so you can see in a sense that Cal Poly is displaying that image. And so if I embed the photo next to text on my website, you can understand how this might simply be my decision to place Cal Poly's display of Armstrong along with comments about him. Clearly, Breitbart's decision to embed Goldman's photo could be seen in the same light, and according to the Ninth Circuit, it should be. But the Tom Brady case was not brought in California or any other state governed by the Ninth Circuit. Rather, it was brought in a lower court in New York, and so the judge is not bound by the decision in Perfect 10. However, she is informed by its reasoning and understands that the legal community has somewhat accepted its conclusions over the years. Surprisingly, the judge decides to look at the situation a little differently, which is why everybody is thinking about the legality of embedding a little more once again. It's like what everyone thought was settled is no longer settled anymore, and that has put the industry a little bit on edge. First off, the judge questioned the Ninth Circuit's conclusion that one must possess a copy to display it, for reasons similar to what I just noted. And if that logical support for the outcome is wrong, then that opens the door to other results. The judge also latched onto another principle which the Supreme Court is increasingly raising in technology contexts. This is a concept called volitional conduct. Without going into great detail, the bottom line with volitional conduct comes down to who is making the choices regarding the violation of copyright interests. So in this instance, we would ask whether Breitbart is making the choice to display the photograph of Durant and Brady, or is the customer somehow making the decision to see it? And based on this notion, I think it's pretty clear here that Breitbart makes the choice, since the photo is already displayed when the customer arrived to read the story. On the other hand, if Breitbart had simply placed a link in or next to the article with instructions that said something like, "Click on this link if you want to see the evidence," then one might say that the customer had made the selection to see what was out there, which in this case is what Manning's Twitter account was displaying. So, based on the concept of volitional conduct, the judge determines that Breitbart made the display by embedding the photograph as it did. And for this reason, the case does not end here in Breitbart's favor. Rather, the parties have to go to trial so that Breitbart can raise possible defenses to copyright infringement, such as fair use, or perhaps contractual terms governing Goldman's use of Snapchat. You may be thinking, wait a minute, what does this mean for Google and how it operates its image search engine, since it does embed the full-sized image if you click on the thumbnail? But remember that the creation and display of the thumbnail is a fair use. And if you think about it, the array of images that you first see is like Google saying, "Hey, if you want to see the full-sized image of any of these thumbnails, then click on it and we will let you see what the source has displayed." Thus, Google probably conforms to the judge's decision regarding the importance of volitional conduct, which is why it has not felt a need to change the structure of its search engine in response to this lawsuit. But there are a host of other sites that regularly show images, as Breitbart did, without requiring any action by customers, especially since, until this case, everyone believed that it was legal. And numerous commentators believe that the judge was wrong to question the Ninth Circuit's ruling in the Perfect 10 case. In fact, those of you involved with web design may have been taught that embedding images is always legal, at least barring the possibility of contributory infringement. So, I am here to warn you that this may no longer be the case, although it is hotly debated. I, for one, believe that the judge's position in this litigation based on volitional conduct is somewhat persuasive, So I would certainly be cautious before routinely embedding images, unless you feel really secure that the display is a fair use or falls within some other limitation. So there you go. I hope you found this interesting as I do. If nothing else, the debate illustrates so well how new technologies strain the application of old copyright laws. I can assure you that there are many other examples that are lurking right around the corner.